Good morning. Welcome to Rights and Security here on Prism TV. My name's Jeff Salat. On our program today, we're going to be talking about no-fly lists. We have had a lot of experience now in the 10 years since the 9/11 tragedy with various attempts to secure air travel. We are a world where we are all on the move. If you are watching our program today anywhere in North America or Europe, you are probably in close proximity to an airport. We all kind of take it for granted that we will be able to get on an aircraft and travel vast distances in short periods of time to conduct business, to visit families, to go on vacation and so on. We take it to take it for granted so much that it's almost like second nature. But do we have a right to fly? And I mean, that's kind of the question that is at the core of what we're talking about. I have Roch Tassé here with me here in the studio from the International Civil Liberties Monitoring Group. Roch, what about that? Is there a right to fly?
Well, that's debatable. Some experts say we do, others say we don't have the right to fly per se. However, under the Canadian Charter of Rights, for instance, we do have mobility rights. We also have the right, the freedom to leave and return to Canada. But if you can't fly, one can argue that these fundamental rights are pretty much reduced, constrained, and perhaps totally violated. In a country as big as Canada, if you can't fly, it's hard to find work in other parts of the country. So your right to livelihood is also being hindered. So it's a very debatable question, but in practical terms, the fact that you cannot fly does restrict your fundamental rights.
Yeah, and we have with us in Birmingham, England, the former Guantanamo detainee, Mozambique, who recently had some experience trying to visit our country here in Canada. Mozam, why don't you tell us about what happened to you recently when you tried to fly, I guess here for some kind of a conference?
Yes, actually I was invited to Canada by a group of people which included Dennis Edney, who's the lawyer for my father, who's a Guantanamo prisoner. And so I was supposed to have been last week touring Canada, which would have begun with going to Toronto and then across right to Edmonton. I was told at the Air Canada check-in desk that my name was on some sort of a no-fly list, and I asked whether this was a Canadian no-fly list, and they said no, it was an American no-fly list. And I said, I'm not going to America, I'm going to Canada. And then they said that after speaking to various authorities and people who are in charge of security on the Canadian mainland, that they weren't prepared to take the risk in the unforeseen event, on the unlikely event, that an Air Canada aircraft is rerouted onto US territory or onto US airspace. So in essence, that was the position. They said this, they maintained it. I tried to speak to more people in positions of authority. They said that this is the case. For me, it is bizarre because since my return from Guantanamo, I have pretty much toured every continent except the American continent. I've even just recently come back from a visit to Egypt and to Libya. And I have to say, for me, it's easier to get in these countries than it has been to Canada. And I don't know what the reason is thus far, other than this being placed on a no-fly list. It's the first time after having visited all across Europe, Malaysia and Sudan and South Africa and Kenya, and the list is endless for me. I've never had this experience before, and it seems quite bizarre to be the recipient of it. And as I said, I've met prime ministers and presidents. I've met, in terms of the resettlement process for the Guantanamo prisoners, I've spoken to prime ministers of different countries, asking them to accept prisoners who can't return to their countries for fear of torture. And I've even been praised in a WikiLeaks cable by the US ambassador to Luxembourg, who attended one of my conferences. So it does seem very, very bizarre.
Now, you are a British citizen, so you wouldn't need a visa to come to Canada. But some of the other countries that you have traveled to, you probably did need to get a visa. Did you have any problems with those countries?
No, as I said, I've never had a problem going to any country, whether it's Malaysia, whether it's in the Middle East, in the Gulf, whether it's Pakistan. I've even returned back to Pakistan, where I was kidnapped from by CIA and Pakistani agents. I've returned to the same house and taken testimony from people who were there and so forth. As I said, I've gone across Europe completely. And in the places where I've required visas, it has been no problem. As I said, I've been into Libya and Egypt, which are now free. But it seems that there is a different set of rules or circumstances that would allow me to come to Canada if I attempted again.
Okay, just to make sure our viewers are clear, you've never been convicted or even charged with any kind of a terrorist offense. You are a British citizen in good standing, and as you point out, the American ambassador in Luxembourg and perhaps others in the State Department of Washington feel that you have been doing a valuable service in trying to find a safe haven for Guantanamo detainees like yourself. So what do the Americans have to say about this? Have you gotten a hold of your new friend in Luxembourg at the embassy there?
Well, I think the problem here is, although we have a change with Obama in terms of the administration, there's not a change of the system, there's not a change of the legal process, and more importantly, there's not a change in the language. So as far as everybody's concerned, even though more than 600 plus prisoners have been released from Guantanamo, nobody's been cleared in the sense that Guantanamo was already said by the most powerful men in the world as a place that houses the worst of the worst. Now, when powerful people are doing that, and constantly doing it without any legal process, and people are released, then how do you clear your name? Because there hasn't been a legal process that puts you in that position in the first place. As you pointed out quite clearly, quite directly, I've never been charged with a crime, I've never been convicted of one. But more importantly, I was interrogated by the world's most leading and powerful law enforcement and intelligence agencies, including the CIA, the FBI, military intelligence, and here in the UK. And despite that, the charges at present are not against me. They're in fact against those people who held us, including the British government, who, like in the case of Maharaj now, have ordered an inquiry into the torture of its own citizens and are facing criminal prosecutions. So where is all this coming from? Why is this happening? I think it's just that there's a refusal to accept that, for the United States in particular, that we simply just got it so terribly wrong. And to accept that we got it wrong in one case means that we have to accept we got it wrong in hundreds of cases. And that, I think, there is a fear that would open floodgates. But nonetheless, the right thing to do here is to change the language and to say that these people who were held in Guantanamo, released without charge or trial, are not terrorism suspects anymore. Because if they were, they would have been prosecuted.
Right. But to get back to the problem that after you're released, you still have the stigma and you can't fly. I mean, you were trying to engage in a transaction as a passenger, a transaction with Air Canada, a commercial relationship. You paid your ticket. You are not in violation of any travel restrictions in the UK. You are free to travel. If you can get to Canada, you're free to travel here without any difficulty. How is it that Air Canada, a private company, is able to tell you, a British citizen, that you cannot visit Canada?
Well, I suppose in essence they didn't really say that to me. They said that they wouldn't be the ones to carry me. If I could find somebody else to carry me, then that's fine. I think the problem here again seems to be, and I remember I tried to check in online. I know normally when I fly abroad, I check in online because it's much easier to do so. I tried multiple times to do so on Air Canada, and I couldn't. So I realized that there's something must be up. There must be something that's blocking me from doing this. I may reattempt coming to Canada again, but here's the thing for me, is that if I arrive in Canada and then I'm told at immigration that I can't enter, it would mean that I would be detained on Canadian soil. And I would be detained up until the point that they find another plane to return me back and deport me. Now, this would be quite bizarre because I would be the first free former Guantanamo prisoner to walk on Canadian soil and then to be detained as a free man on Canadian soil. while Omar Khadr is still being held in Guantanamo. It would be politically, I think, extremely difficult to do this. But nonetheless, being placed on a no-fly list can put you into these sorts of ridiculous situations where your basic freedom to travel is being dictated by, in essence, the foreign policy of another country. I don't know that Canada has any problem with me in terms of Canada itself. And the only thing that's been cited thus far is in the event that the flight is rerouted to America. So what I need to ascertain is whether the Canadian authorities themselves have, in and of itself, a problem with me, or whether it's simply being on a US no-fly list.
Now, when you first learned of this, how far, I mean, was it at the gate when you were going to check in? Was the first time you learned that there might be a problem? Okay, I think we're having a difficulty here with our audio to Birmingham. So let's talk to Roch Tassé about the difficulty that Mozambique has run into. I mean, what strikes you about that?
Well, that's consistent with what we knew about the U.S. secure flight program. So he was told by Air Canada that he is on the U.S. no-fly list. Air Canada, as a matter of fact, because most of its flights are either going to the United States or overfly the U.S. when they go to Europe or Asia, as a practice, basically, for administrative facility to use the U.S. secure flight for all its flights. So 72 hours before departure, they send the names of all passengers and all the information they have in their reservation systems to Homeland Security. They get a boarding result back from Homeland Security telling them whether they may issue a boarding pass, send the person to secondary enhanced screening, or deny boarding clearly. In this case, the airline was instructed to deny him a boarding pass.
Okay. Mozam, I think you're back with us now?
Yes, I am.
You're hearing us?
Sorry.
Okay, good. Now, we're talking generally about mobility rights here. We live in a world where we all kind of expect that we're going to be able to go from point A to point B and without any great hassle. But you've found yourself restricted now. What kind of an impact has this had in your own life, in your own plans, things you might want to do?
Well, clearly, I guess I'm sort of thankful that it didn't happen when I arrived in Canada, but clearly, being in that situation, being prepared and telling your family, telling everyone, conferences being prepared, thousands of people, thousands of dollars being spent in pursuance of this, which I thought was going to be a very important conference, as being the first free former Guantanamo prisoner to walk on North American soil. It has upset a lot of people, including myself, of course. It has caused a lot of, as I said, financial, psychological difficulty to me in particular, because now you have this fear already as somebody who's been held, who's been abused, who's been tortured, who's been beaten without charge or trial, to now come under some sort of spotlight, as it were, and told that he's on a no-fly list, and affected by a country that he's not even going to. So I'm not going to America, and I'm not attempting to go to America, and I don't have any intention to do so as long as attitudes like this persist. But nonetheless, Canada, we've always seen in Britain, Canada as some sort of an extension of Britain. You still have our monarch on your currencies. So, and Canada generally is known to be, and Canadian people are generally known to be, very polite, very accommodating, very tolerant, and your laws are the sorts of laws that people would expect afford justice, and are known for it. So when Canada takes a position like this, for me as an individual, I have to go around telling people. I will go and tell people that Canada's done this to me. And I've never been to Canada. I don't have a problem with Canada. There's no issues between me and Canada, only that this has happened, and there isn't any explanation except that it's based on American policy. And I think this should be a cause of outrage, not because people care about anything that I have to say. Canadians may not like what I have to say about Omar Khadr's case and others, but simply because this does infringe upon Canadian sovereignty. It infringes upon, it walks into the territory of telling Canada who it can and cannot have allowed on airlines that are run in its name. Air Canada is like the British Airways of Canada. So I think these issues are very important. They're very important not just for me, but they're important for people all around who understand the basic concepts of freedom of movement.
Well, Mosem, thank you very much for being with us this morning. We hope that you are able to visit us sometime here in Canada, and that you will be able to travel on our Air Canada and have a safe arrival.
Well, perhaps the next time I might try to attempt to come via the North Pole. I've been told that that's as far as from America as you can get.
But you have to go to China first to get to. Okay, thanks very much, Mosem.
Well, thank you.
Okay, now we are back with Roch Tassé here in the studio. We're almost 10 years since the 9/11 attacks, where aircraft were used as weapons of mass destruction in the attacks on the Twin Towers and in the Pentagon in New York. Isn't it kind of natural to assume that civil aviation authorities, law enforcement people, intelligence services around the world were going to try to beef up security measures and perhaps try to identify people early on who might pose some kind of a risk?
That's quite legitimate, and there are means that the best protection on their airlines were the special doors to prevent passengers from entering the cockpits, screening passengers for bomb on the ground. I mean, once you've screened people, once the cockpit is secured, there's not much a person can do once they're on the plane. And if you have if you want to go further and do prevent some people from boarding because you think they are a risk, you better have more than suspicions or allegations based on intelligence services. You must have some kind of evidence. These evidence should be presented to a judge for a judicial review to see whether there is judicial reason to restrain the rights of such a person. But this is not the case with no-fly lists. People are put on the no-fly list on the mere basis of intelligence gathered by CSIS, CIA, intelligence services, even the RCMP, but it's not at the level of what we consider legal evidence in front of a court. So it's really a discretionary decision, arbitrary decision, no judicial review. The person will never know that they are on the list until they arrive at the counter. Once you find out you're on the list, there is, in the case of the U.S. list, there is no recourse, no office of reconsideration. You cannot have your case reviewed. There are 16 agencies in the United States putting name on this no-fly list. And as I said, without any process where a person can have its case reviewed. So you're there for life, basically, because you cannot be removed. So it's a process that lacks due process. It violates all the elements of fundamental justice. Imagine in the case of a violent person, in the case of a divorce, let's say, and the police want to restrain the access to the husband back to his house. The police alone cannot issue a restraining order. They have to go in front of a judge, have some level of evidence that this person does represent a risk, and only the court can issue a restraining order. A no-fly list is a restraining order without any judicial review, merely on the decision of the police or intelligence agencies. And what we know in the public domain about the level, the correctness of intelligence, there's been so many mistakes. We've had the cases in front of commissions of inquiry where we know that the allegations, the suspicions were not founded. They made so many errors. So when you've got a list of 60,000 plus names on the no-fly list, you can just imagine the level of names on there.
Is that the number, 60,000?
We don't know the exact number, but it's a number that's often being circulated.
Now, Mosem makes the point that he wasn't planning on traveling to the United States. I mean, there are ways that governments can restrict certain kinds of people. You know, a lot of people in the world to come to Canada or the United States are required to go through a visa process where they're screened. But he wasn't going to the United States. He was going to Canada, and he was told, well, you know, it's a transatlantic flight. If there's bad weather or whatever, you might get diverted to the United States. I mean, how crazy is that? That Canadian entities like Air Canada are making their decisions on the basis of somebody else's view, somebody in Washington, some anonymous person, saying that, you know, he may be a risk.
Well, it is an aberration on Canadian sovereignty. And with the U.S. secure flight, it's not only flights that could be derouted to the United States, it's all flights that overfly the U.S. territory. For the first time, the U.S. in the history of aviation is imposing restriction on who flies over their skies, never landing in their territory. That's what the new secure flight rules are all about. And in the case of Canada, most international flights do overfly the United States back and from Europe. Approximately 80% of flights overfly the U.S. Just when you turn around the Montreal airport, you automatically go over New York State. So you fall under the new rules. All the flights between to and from Latin America and the Caribbean, all the charter flights for winter holidays, all these flights now fall under the new secure flight rules, which means the airlines cannot issue a boarding pass without the authorization of the Homeland Department. Not only being told who cannot fly, even to be allowed to fly, you need authorization from the United States. So any of our Canadian members of Parliament traveling just about anywhere in the world need the permission of Homeland Security. And if they were denied permission, there is no recourse whatsoever. Half the cabinet of the Bolivian cabinet, half of that cabinet is persona non grata in the United States. So in terms of diplomatic relations, if Canada invites a minister from Bolivia to come to Canada, it is the U.S. who decides whether this person can fly to Canada or not. We can think of our refugee policy. If Canada accepts a refugee, let's say from Colombia, and the United States does not recognize the right of Colombians, their refugee rights, the United States ultimately can prevent this person from boarding a plane in Bogota to receive asylum in Canada. So it goes really far in terms of the impact on Canadian sovereignty.
Now, just to be clear, these we're not talking about people who refuse to go through a security screening at the airport. I mean, everybody before they get on that aircraft, whether you're on the list or not, is going to go through very tight security. I mean, what possible threat could it be if your plane is diverted to Boston for a couple of hours for bad weather? They know who you are. If they don't want to grant you admission to the United States, you can sit on the aircraft or go to a secure location at the Boston airport until you can continue your journey. I mean, what's the threat or the problem that they're worried about?
Well, absolutely. You're right. There's not really a real threat as long as you've secured the plane, the cockpit, you've screened people before they board. And we know what the level of screening is presently. It's almost impossible for anyone to get on the plane with a bomb or... So one can really question what it's all about. We've had stories talking about what it's all about. For instance, there was a Monde Diplomatique reporter covering Central America, working for Le Monde Diplomatique, very well known in Europe, on his way to Nicaragua on Air France. His plane was diverted. They were halfway, almost reaching the U.S. airspace, when the plane was diverted to Martinique or Guadeloupe. I can't remember which country specifically, because this guy was on the plane. Well, what we know about this journalist, he had been very critical of U.S. foreign policy vis-a-vis Central America. That's the only explanation people could figure why he was on the U.S. no-fly list.
The aircraft was already in the air.
Yes.
And it was diverted to an island.
Yes.
Now, if Air France is required to give the U.S. 72 hours notice, what happened in this case? I mean,
I believe in this case that the new rules were not totally in place for secure flight. So it's questionable how the U.S. got a hold of the passenger list in this case.
Yeah. What would happen if countries like Canada...
Actually, in the old rules, sorry Jeff, in the old rule, the airlines had to give, to send I suppose this plane was in transit in Miami on its way to Central America. And the passenger manifest had to be sent to the U.S. 15 minutes after departure. So they were already in the air by the time Homeland Security received the passenger manifest. Yeah. There was another case of a legislative assistant to a member of the European Parliament who was in the same situation. He was coming from Belgium, and his plane was diverted before they reached the United States. And this legislative assistant was known for having criticized the agreement between the EU and the United States for the transfer of passenger information. And he ended up on the no-fly list.
Thank you, Rock. We're joined now by Ben Weisner in New York City. Ben is with the American Civil Liberties Union. We've been talking about the no-fly list and how the American blacklist is impacting people who are traveling in other parts of the world as well. Now, we kind of thought this here in Canada, perhaps naively, we kind of thought there was going to be a sea change on these kinds of things when Barack Obama became the U.S. president. What happened, Ben?
Well, I think that in some sense, the no-fly list situation has gotten worse, not better. And that has everything to do with politics and nothing to do with national security and human rights and the law. The truth is that in the beginning of the Obama administration, there was high-level activity and support within the administration for bringing some reform to the really sprawling, out-of-control counterterrorism watch lists that developed in the U.S. after 9/11. And all of that really ground to a halt on December 25th, 2009, when a Nigerian teenager tried to blow up a plane over Detroit. And what the Obama administration realized at that moment was that this was more of a threat to his reelection than it was to national security. And since then, there's been really a massive expansion of the no-fly lists for the reason that the U.S. would prefer to inconvenience or really violate the rights in a serious way of thousands of people than to have one person slip through that net who it turns out should have been on the list. The scandal here was that Mr. Abdul Muttalib was not on the U.S. no-fly list, and bureaucracies respond to those kinds of errors by massively increasing the number of people on the no-fly list. And so I think, but for that incident, there might have been a real chance for reform in the United States, and unfortunately the trend is in the opposite direction.
But in the case of the Detroit shoe bomber, or attempted shoe bomber, it wasn't just that he wasn't on the list, but that the American authorities had all kinds of other intelligence that might have put him on the list, but the people who make the decisions on who gets on the airplane didn't seem to get that information. So, I mean, how's this an argument for toughening the no-fly list?
Well, I didn't say it was a good argument. I said it was an argument. It was a political argument, and you could add to the questions that you just asked, why let somebody with a bomb onto a plane? The better way to deal with security is not to keep the person off the plane, but to keep the dangerous materials, the weapons or explosives, off the plane. What we saw in the months right after that failed terrorist attack, and we should point out it was a failed terrorist attack, even though in the U.S. it's treated as if it was a successful terrorist attack, was really thousands of people being added to the no-fly list, including many United States citizens who at that time were traveling abroad, visiting family members in other parts of the world, in Europe, in Yemen, in Cairo, and those people literally found themselves stranded in foreign countries. They had been banished effectively by virtue of being placed on the no-fly list. There is no Royal Caribbean cruise line from Aden, Yemen, to San Francisco or New York. And so by virtue of this secret bureaucratic watch list, we had people who were being fundamentally deprived of the most basic right of citizenship, which is the right to reside in one's own country. We filed a lawsuit, which is still pending, challenging many aspects of the no-fly list. The one part of that lawsuit that has already been successful is that the United States did agree to repatriate its citizens and lawful residents who were effectively stuck abroad by virtue of this list. And since that time, anytime we've heard of someone in that situation, we've been able to arrange for that person to fly home. But that only points to the irrationality of the entire system. If the U.S. can safely arrange for those people to fly home, why can't it safely arrange for anybody to fly anywhere? I mean, do we honestly think that if we captured Ayman al-Zawahiri in Sudan, we would say we can't fly him to the U.S. because he's on a no-fly list? There would be a way to do this, of course.
Well, he wouldn't be flying on American Airlines, though.
No, he wouldn't be. But there's
CIA Air.
There's another irrationality here, which is that, again, the whole category of people who are on this no-fly list is people who essentially the U.S. government considers too scary to fly, but not scary enough to arrest. If we really had evidence that they were involved in terrorism, we wouldn't turn them away from flights, we would arrest them. And if we arrested them, then a whole series of rights would kick in. We would have to present evidence against them, they would have a right to defend themselves. But we end up in this ironic situation where the less evidence the government has, the fewer rights the person has. And so the deprivation takes place really without any process for the person to get off the list. And I think you have to question the seriousness of this whole effort. My clients who were, for example, in Yemen and were denied boarding, we're told, you're on a no-fly list, you can't get on this plane, go to the embassy to work it out. Is that a place where terrorists should be sent? To the United States Embassy in Sana'a? If we thought these people were terrorists, we wouldn't be letting them into our embassy. We wouldn't be letting them on buses or ships or anywhere else. I really think this is about political cover rather than national security.
And as you point out, though, thousands of other people are inconvenienced as a result and have no way of clearing their names. What's the danger of these blacklists proliferating? And let's say you want to get on an Amtrak train in Grand Central Terminal. Is it a possibility that because you're on a no-fly list, you might also be on a blacklist someday for rail travel?
Well, the answer to that is not yet. Although Senator Schumer and others in the United States have proposed expanding the no-fly list to rail travel. I will say this, the logic of the system shouldn't really distinguish between flying and taking trains. If we really think people are terrorists, we wouldn't want them in either place, but of course we wouldn't want them to be free either. So I think it's a very serious concern that what started with air travel will expand, and so I think that makes it all the more critical that we establish some fair process for people to object and to clear their names. This is something that the U.S. Congress has looked at in the past, particularly in response to absurd cases where American politicians or children found themselves either on the list or subject to extra screening. Congress has demanded that there be a better process for people to get off the list, but the process as it exists right now is the following. You can go to a government website that's operated by the Department of Homeland Security, and you can supply any information you want. The problem is, the government refuses categorically to confirm or deny whether you're on the list in the first place, or to provide any basis for your inclusion on the list. So you don't really know what you're responding to. You don't know what kind of evidence or innuendo has resulted in your inclusion on the list. You don't know how to respond. The complaint goes to an agency, the Department of Homeland Security, that has no authority to remove you from the list. And you get a letter at the end of that process that says, thank you for your concern. If there was any action that should have been taken, it was taken. And that's the end. And the way that you find out if you're still on the list or not is to go through the expense and humiliation of purchasing another ticket and going to the airport and seeing if you're allowed to board. That's not acceptable. And we have filed a lawsuit saying that it's unconstitutional, at least with respect to U.S. citizens and lawful residents, that our due process clause requires at a minimum that people be given a fair opportunity to clear their names, be given the basis for their inclusion on the list, and a fair hearing to remove themselves. And the rationale that we've gotten in return from the United States is that we can't tell people that they're on the list. That would tip them off. Well, our response to that is that when you go to an airport and try to fly, you're denied boarding, and you're surrounded by 40 law enforcement officials, you've been tipped off. Whatever rationale you have about tip-off is demolished after that point. And at that point, there's really no legitimate national security reason for depriving an individual in that circumstance of due process and a fair hearing.
those of you who are watching the webcast, on your browser there is a chat box. If you want to send us some questions, we'll be delighted to take a look at them, and our experts here today may be able to help you out. Now, Roch Tassé, here in Canada, how similar is what you've heard Ben Weisner say? How similar is the situation in Canada?
Well, in 2007, Canada established its own Canadian no-fly list with an agreement to the U.S. that the U.S. would not impose the U.S. no-fly list on Canada. It was a much more restricted list. There is an Office of Reconsideration. If you are on the list, you can apply to be reconsidered, although the one case, public case known of a person asking to be removed, in spite of independent consultants saying this person should be removed, the transport authority still kept that person on the list. And the process for listing is the same. It lacks it's a total lack of due process. It violates the elements of fundamental justice. There's no judicial review. But with the U.S. Secure Flight now being in place, the Canadian list is almost irrelevant. The airlines in Canada are using the U.S. list, which causes other kind of problems we haven't talked about, problems that for non-American citizens, people, Europeans or Asians or Canadians traveling, or Latin Americans who have no intentions of ever going to the United States. For all over flights, the U.S. now receives the passenger information on all these passengers. So a lot of private information on citizens around the world are stuck in American databases forever, even though these people will never go or have no intentions to go to the United States. So the United States is keeping track of the mobility of basically all citizens of the world if they come near North America.
Yeah. Now, we just recently had an election here in Canada, and actually just days before the election, the federal parliament enacted legislation, Bill C-42, to bring the Canadian process in line with the Americans. Now, that happened all rather quickly in the last days of the last parliament, and then we were into an election campaign. Why hasn't this become a political issue, or more of a political issue in Canada?
There was a fairly harsh debate, actually, in Parliament over Bill C-42, which was not covered by the media. Three of our four parties agreed with Bill C-42. Bill C-42, in essence, was amending the privacy regime in Canada, PIPEDA, to allow the airlines to exchange information with the United States for overflights. Until this point, it was illegal for Canadian airlines to share passenger information with the United States unless you were going to the United States. Now, for all over flights, the U.S. receives information on those travelers. Only the NDP opposed the bill, saying it was a violation of Canadian sovereignty. The reason the other parties agreed with it, especially the Liberals and the Bloc Québécois, was because of the case of the Bloc, for instance. Air Transat is based in Quebec. The U.S. was blackmailing Canadian Airlines by telling them you will lose your landing rights in the United States, or you won't be able to fly to Latin America over the U.S. You'll have to change your routes around the Atlantic. So the cost of traveling for Canadian Airlines could have increased by as much as 40%. So for commercial interests, our politicians, unfortunately, yielded and voted in favor of this bill to amend the privacy regime of Canada. And we have to keep in mind that the U.S., tell me if I'm wrong, Ben, but in the U.S. there is no equivalent of such privacy restrictions and privacy regime as we have in Canada, especially in the public sector.
How about that, Ben?
Well, I guess I'm not familiar enough with the Canadian privacy regime. There is a Privacy Act in the United States which chiefly functions to prevent the government from releasing certain kinds of data to the public in certain instances, but I don't know how it compares to Canada. I'm sorry.
Okay, now we've been talking about, we've been using this euphemism, no-fly list, It's a blacklist. People don't like to call it that, but that, in effect, is what you're doing. You're blackening somebody's name. Now, in addition to all the other rights that we enjoy as human beings, I have a right to my own good name. Yet I may be blacklisted, without any reason, without knowing what the reason is, without being able to challenge it. I mean, aren't there laws, just anti-defamation laws that can be used to, for people to try to clear their name? Ben?
Well, I think the Constitution of the United States is such an anti-defamation law with respect to the government. And we have argued in our lawsuit that citizens and lawful residents of the U.S. Have a right to be free from unwarranted stigma at the hands of the government. And nothing could be more stigmatizing than being paraded around an airport as a suspected terrorist. Now, of course, the government's response to that likely will be that they refuse to confirm or deny whether anyone is on the list. They haven't stigmatized anyone, but that, of course, is a real legal fiction. The frustration for us is that, as with almost all national security-related litigation in the United States, we spend most of our time trying simply to get the case heard. We have tried to raise all these due process concerns that I've been describing over the last few minutes, and the government's response has been essentially, you filed this case in the wrong court. You can't be in this court, you need to be in that court. And of course, when we get to that court, they'll make some other kind of procedural defense. And so, we're now nearing the 10-year anniversary of 9/11. We still haven't had a court rule on the fundamental legality of what the government is doing with the no-fly list, as well with many of the other U.S. counterterrorism policies.
You had a case a few years ago, I think it was 2007, the El-Masri case, where the ACLU acting on behalf of Mr. El-Masri tried to go a little bit further and go behind the government and actually bring suit against an aircraft manufacturer who was using an aircraft to illegally bring somebody across the Atlantic, I guess. Tell us what happened there.
Well, these cases actually are related to the CIA's extraordinary rendition program.
It's kind of the reverse of the no-fly list. It's the you-must-fly list.
Right.
Yeah.
We're talking about a program in which the United States government essentially kidnapped foreign citizens off the streets of foreign countries and transported them in private commercial planes that were leased by the CIA, either to countries that were notorious for their torture techniques or to secret CIA-run black site prisons in places like Afghanistan and Europe. We sued a subsidiary of the Boeing Corporation called Jeppesen Data Plan, which did not manufacture these planes, but effectively served as the CIA's travel agent for the rendition program. In order to facilitate the CIA's clandestine renditions, it filed false flight plans with foreign aviation authorities. It arranged for security, overflight permission. Essentially, without the services of this company, the rendition program literally could not have gotten off the ground. And we had a witness from this company, a former employee, who said that it was openly discussed within this corporation that these were CIA torture flights, but that the CIA spared no expense, so that it was quite profitable for the company to do this. Now, we brought this case after we had been unsuccessful in going after the CIA more directly, because the government had invoked the so-called state secrets privilege to say that even if all these allegations were true, and there's really no dispute that Mr. El-Masri, an innocent German citizen, a victim of mistaken identity, was kidnapped and tortured by the US, but that even if that's true, state secrets would prevent the litigation of the case. It would harm national security to allow this case to go forward. And unfortunately, the government succeeded with that argument. And once again, in our case against Jeppesen Data Plan, the Boeing subsidiary. And so again, I hate to sound like a broken record, but now almost 10 years removed from 9/11, not a single victim of the Bush administration's torture regime has had his day in court in US courts because of overbroad applications of secrecy and immunity doctrines that have shielded the perpetrators of these offenses. And so it's just another example. I think with the no-fly list, eventually we will succeed in getting a court to hear these constitutional claims because we're talking about US citizens on US soil. But it's been a real challenge when the government invokes national security in the US. The courts still respond as if we're in some kind of state of national emergency, as if this threat of terrorism is an existential threat and not the really contextualized threat that we ought to see it as.
Now we're, as you point out, almost 10 years away from the 9/11 attacks. we've learned a lot about those who were involved in those attacks. Would the 17 or 18 people who were involved in the plot on September 11th, would they have been blacklisted if that regime had been in place at that time?
That's a question that I can't answer. It may be that there are a whole host of ways in which they would have been prevented from doing this.
But they were all in the United States legally, as I recall.
Well, they were, but that might not have been the case. It might have been much more difficult for those people to have obtained visas in the first place to be in the United States, which is the principal way that the United States protects itself from unwelcome foreigners who it doesn't want to have inside the country, and not by using a no-fly list. I mean, they are also people who all flew into the United States. I don't know the answer to that question, because even with a sprawling, much too large no-fly list, someone like Mr. Abdul-Muttalib, slipped right through. It will never be the case that using a system of watch lists will be an efficient and effective way to protect the United States. What it ends up doing is diverting massive resources to chasing after false positives or people whose names resemble those of people's names on the list, when those resources would be much, much better focused on trying to track down individual threats long before they reach airports.
We've seen instances where there have, in fact, just been simple mistakes. Roch Tassé, tell us, what is the recourse for somebody who has a name similar to somebody else and shows up and planes take off, they have their own schedules. I mean, what do you do?
We've had dozens and dozens of cases reported to us of people who have the same name as somebody else or similar name as somebody else on the list, what we call false positives. So these people are not the real people on the list. Under the Canadian list, if you're not the real person on the list, you cannot apply for reconsideration because you are not the real person on the list. And people are being told you will have this problem. Eventually they're allowed to fly, but after losing an hour or whatever length of time to double check their name and identity, making sure they're not the real person on the list. In the case of the US list, there is a program for false positives called TRIP, where if you are a false positive, you can apply to have a redress number, which in theory will allow you to speed up your process the next time you fly. We've had cases of Canadians who were false positive, who applied to TRIP in the United States and were told, we cannot give you a redress number because you're not a US citizen, you're not on a US airline. So these people are still considered false positive the next time they fly. So waste a lot of time, sometimes miss their flights.
So even though Canada was not the target of terrorism attacks, even though none of the 9/11 terrorists had anything to do with Canada, we still have a system that you're describing sounds even more stringent than the American system in terms of trying to get your name cleared if there is some kind of mistake.
Well, in the case of Canada, it's all about to have good relations with the United States to show we are good neighbors so that the border remains open. The U.S. has really tightened the Canadian border. So the whole economic elite in Canada is putting pressure on our government to collaborate as much as possible. And I think we bend forward, backward as much as we can to please the Americans for the sake of keeping the border open for trade. It's all about trade and commerce. It has nothing to do with security. We don't have the same security threats. We're agreeing to play this game out of fear with the United States to keep the border open. There are now talks. In the next couple of months, we will see a concrete plan for what's called the North America Security Perimeter, where the whole perimeter of North America will become the border for North America. We will have U.S. standards being applied for everybody entering North America. So all the standards used by American borders will be used in Canada for incoming flights, for people coming in. We will have shared data bases, and from immigration databases will be integrated with those of the United States. Our border services will be integrated with the border services of the United States. We're really walking into what I call deep integration, North American integration with the United States security regime. We think we've seen it bad so far in Canada. We're just starting to see what's coming up.
Well, presumably, if we're in negotiations, it's a two-way thing, and Canada's not without some leverage of its own. I mean, Ben, I hate to keep picking on you. I don't expect you to be the spokesperson for the U.S. government, but you're the only American we have at the moment.
Yes.
What would the U.S. reaction be if Canada said, oh, okay, you know, look, we're going to bar American flights over Canadian airspace, you know, these polar flights coming from Europe or Asia into Chicago. You know, that in retaliation for your high-handed action in imposing your list, we have some leverage too. What do you think the reaction would be in Washington?
Well, let me not pretend to speak for the U.S. government. Let me instead speak as a U.S. human rights advocate, and I would say that that's really one of our hopes. One of our hopes is that what we've not been able to resolve through constitutional litigation may be resolved through sovereignty negotiations when the absurdity of our watch list regime starts to affect neighbors and other countries abroad and gets the attention of the political elites in those countries. When we start to see the effects ripple out throughout the rest of the world, I hope that our neighbors, our allies, our friends bring some pressure to bear and say, why does the United States have to have this system that departs so radically from any other Western democracy, including Western democracies that have been regular victims of terrorism? Why is it that we insist on giving complete discretion to the executive branch without any fair process to people on the list? And why do we think that we can impose that on the rest of the world, you know, as if the rules that apply to others don't apply to us? So I would say, from where I sit, I would really welcome seeing this issue gain further prominence in Canada, in Mexico, also in Europe, in other places where the effects are going to be felt. Because I think that may help bring the kind of pressure that's needed on the Obama administration to adopt a more sensible policy.
Ultimately, many of these decisions are made in a court. If you can find a court willing to take a look at something that is proclaimed by the U.S. government to be off limits because it's national security. But we also know that at the highest level, your judges, your appointed judges, have tenure, and it takes a while for things to change. Will the Obama administration, well, with its appointment so far to the senior courts in the U.S., and with the opportunities, are we likely to see some changes in years ahead? In the view of this national security, you know, you cannot discuss it.
Right. Well, that's a fair question, but I think that it's a difficult one to answer because in some sense it presumes that the Obama administration would like to see judges who support more of a human rights perspective on these areas, and I'm not sure that's the case.
But wasn't Obama a constitutional lawyer at the University of Chicago? I mean...
yeah, it's odd what the legal and political debate over terrorism has done to politics in the United States. It really is a reason-free zone. A colleague of mine said something very interesting in the Washington Post. He said, the Republican Party practices the politics of fear. The Democratic Party practices the fear of politics. And that's a pretty lethal combination for human rights when it comes to overbroad national security claims. I do think that what you pointed out, that our federal judges have life tenure, does provide a safety valve here. You saw even a conservative Supreme Court, a conservative-dominated Supreme Court, rebuke some of the detention policies of the Bush administration, that they were a bridge too far for that court. The notion that you could lock people up and throw away the key and not give them a lawyer and not give them a hearing. I hope that this is one of those instances. The idea that an American citizen can have his name in a secret government computer somewhere, based on nothing that he knows, based on perhaps lies and innuendo, and have no forum for clearing his name. And I hope that a court will understand that in 2011, flying is not some kind of convenience or some kind of luxury, but an absolute necessity. When work and family take people all over the world, you can't simply give someone a canoe and a paddle and say, you know, go there some other way. It's a really integral part of modern life.
Rock, in Canada, our Supreme Court has been unanimous in many of its constitutional decisions involving rights. The Harper government, re-elected now with a majority, has spoken out about what they see as judicial activism and judicial activism of the wrong sort from their point of view. Are we likely to see any changes in attitude as new judges come up for appointment at the Supreme Court level? And if you were on the parliamentary committee looking at an appointment, what would be the kind of questions you would ask in regards to the rights issues we've been discussing today?
I'm not a lawyer by trade or training, so that's a question that I'd have a hard time to address. I only know what people have read in commentaries in newspapers and what we've heard. There is fear that the Harper government could appoint more right-wing thinking judges.
But it'd be fair to say, though, Canadians now have seen the Charter of Rights in so many cases as a protection against government action. That in 1984, when the Charter was enacted, I mean, there was a lot of skepticism about that. Have we developed a rights culture here in Canada, a more sophisticated and mature rights culture?
To some extent. Until recently, in the last couple of years, we've had judgments though where the Supreme Court rules that something is not right, but they stop at the level of remedy, then they throw the ball back at Parliament to fix the problem. We had this example with the security certificate process, where the court said these are basically secret trials where the person cannot defend themselves, something's not right, it violates due process, and then gave 1 year to Parliament to come back with a new regime. So that seems to be the tendency with regards to rights lately, that the court stops short of imposing the remedy, recognizing the right, however.
Ben, we have, during our own debate here in Canada about enshrining a Charter of Rights in our Constitution, looked to the American example of the Bill of Rights and looked at it as it being a very good example. But we're now seeing post 9/11 all kinds of things that give people pause. I mean, are these things cyclical in the U.S.? Is the pendulum going to swing again, do you think, in terms of public attitude towards rights?
Well, yes, and we see that judicial attitudes very often follow public attitudes when it comes to rights, and it has indeed in American history been cyclical. My organization, the American Civil Liberties Union, was founded 90 years ago in the wake of a very sort of similar response, hysterical response. It was after World War I. People were nervous about the Bolshevist revolution in Russia. Immigrants and anarchists were being rounded up in the United States and locked up and abused and deported. And so the ACLU was formed as a bulwark of individual liberties against those kinds of government abuses. You saw again during the Second World War that 100,000 Japanese Americans were rounded up and put into camps. And then, of course, later on, there was remorse, apology, compensation. And I think the expectation in the U.S. was that 9/11 would be eventually seen as part of that cycle of overreaction and then balancing out. The concern that we have is that there are certain aspects of the national security state that are very, very difficult to disentangle and unwind. It's easier to build up a surveillance complex than it is to dismantle it. And although President Obama has been very eloquent and unequivocal about speaking out against torture, for example, he has embraced some of the elements of the Bush administration's post 9/11 regime, including the surveillance state and including some of the detention theories that are in play in Guantanamo.
Thanks, Ben. We're getting our first question now from one of the viewers. The question is, are there international agreements to facilitate the logistics of no-fly lists and denial of entry to the U.S.? For example, if someone's visa has expired, but they aren't allowed to fly home, or if a U.S. or Canadian citizen and potential terrorist isn't allowed to fly home. Presumably the country they are stranded in doesn't want them either. So what happens, Ben?
Yeah, this was very interesting. Something like this came up for one of the clients in our litigation. He ended up finding himself stuck in Ireland. He's a U.S. citizen. He had been living in Saudi Arabia. He was transiting through Ireland to visit a family member, and yet he was unable to get back to the United States, and he kept getting his 30-day permissions extended and extended. Now, we didn't reach the point where Ireland said, we're going to deport you, and we have to deport you to the U.S. That would have been a very interesting little crisis. He managed to fly successfully to Mexico and cross into the United States over land. But I think it's a very, very important question. By effectively banishing our citizens by virtue of this no-fly list, we are assuming that there's some other country that will allow them lawfully to stay there. But that is could turn out to be a false assumption. And that may be why, Jeff, the U.S. has been sensitive to this issue of citizens and legal residents being stuck abroad and has worked with us mainly behind the scenes to make sure that all of those people are repatriated by plane.
Have we had any Canadians? I guess we have actually had Canadians who've been stuck overseas because of no-fly lists. I'm thinking of the fellow who was hanging out in the embassy foyer for many, many months. Why don't you tell us about that, Rock?
Mr. Abdelrazik.
Yes, Razik.
Yes,
Razik.
that's a different case. He actually was on the United Nations US 1267 list, which is another regime, which is not the US no-fly list. He had been put there, however, as far as we know, by the United States by the Security Council of the United Nations. And by virtue of being on that international list, he was not able to fly anywhere. So he was stuck in, which country was it?
Somewhere in East Africa, I've
yes.
forgotten. Yeah.
And had to take asylum at the Canadian Embassy for over a year. And Canada would not repatriate him back, saying, well, he's not allowed to fly. Eventually, the federal court in Canada recognized that Canada had to repatriate him, and he was found by the RCMP and by CSIS in Canada not to represent a risk. There's no charges against this man, and ever since his repatriation in Canada, he's trying to get off the United Nations list, and that process is still going on. So he's not off the list because under this UN regime, the country who puts you on basically has a veto power.
And that's it.
About removing you. And in this case, it's the U.S., and they still insist that he remains on the list. So we're still struggling with him and other groups and the courts to try and get him off the UN list.
Okay, we've got another question from a viewer. This, I think, is prompted by our experience in Canada with what are called the security certificates, where people are ordered deported, again, on vague reasons and without having a right to know what the evidence is against them. And we've had a process develop here that in order to challenge these proceedings, these deportation orders, if you will, that we have special advocates who are able to see the evidence, and they would advocate on behalf of the person who's being, in this case, we're discussing blacklisting. So our caller says, as a parallel in Canada, there are special advocates who are allowed to view confidential evidence on behalf of people under security certificates. Would a representative of that sort be useful or adequate for reviewing the reasons for someone being on a no-fly list? Rock, what do you think?
Well, in the case of the special advocates for security certificate, the lawyers of the defendant still do not see the so-called evidence, or it's not even evidence. Some of the information used in those courts, the threshold is lower than evidence that would be considered in the criminal court. So we're still talking about allegations, suspicions, hearsay, informations from a third country. The sources are not known to the defenders, so it's really hard to defend yourself. So I'm not sure this process would work in terms of the no-fly lists. And in the case of the no-fly list, it's not even in front of a judge. In the case of security certificate, at least you're at the federal court level with a judicial system. the no-fly list is an administrative system whereby intelligence and police agencies together behind closed doors put people on the list. Even if you had a special advocate there's no judge. The threshold, the standards is so low. It would never stand probably in front of a court. So I don't think special advocates in this case is a solution at all. At the very minimum, it should be a judicial process.
Okay, here's a question for me. Has the mainstream media done a good job explaining this issue to the general public? Well, I can't speak on behalf of all mainstream media in the world or even here in Canada. I'm retired from that business now. But no, I don't. I don't think we've done a fair enough job of explaining this, because we always feel that this is somebody else's problem. This won't happen to me. I'm a law-abiding citizen. You know, I don't have anything to worry about. And if somebody else has a problem and is blacklisted, there's probably something there. You know, that when there's smoke, there's fire, and that kind of stuff. We have a deferential attitude that gets picked up and reflected by media coverage. And just an observation from north of the border, I think this is a particularly more acute problem in the United States, where you see public opinion polls indicating that the U.S. public is so misinformed on many of these issues that you have large segments of the population that believe that there were weapons of mass destruction in Iraq, that the President of the United States is not a U.S. citizen, is a more recent example. And if I were the editor of the New York Times or the producer of a news program in the United States, I'd be saying to myself, I'd be looking at this data and I'd be saying, you know, we have really let the public down. How can there be this many people who are believing nonsense? We have really been inadequate in the job that we are. By our status in society, we are required, it's a responsibility, not just a right, but it's a responsibility to report. And a secondary question we've got for you, Roch, if people knew about the true depth of this problem, how do you think they would react?
I think if people knew the real impacts of all of this, they might react and push back on governments. But unfortunately, like I was talking about passenger information going into the databases of the United States, people have no idea of the amount of information that actually goes to a country which you have no intention to ever going to. People do not understand, I think, the implications of the U.S. having access to all this information about you. A lot of this is happening in the virtual world through, we're talking about databases, the computer, IT world. It's not physical. If there were roadblocks at every bridge in Canada, when you cross a bridge with your car and you were asked to show your paper and they controlled who was traveling, I think people would really react. We're in the same regime, except it's all in the virtual and cyberspace. People do not see the actual impact of all these measures. That's one explanation of why there's so little reaction. And also, as you pointed out, the medias have not covered these issues very well, so I don't think there's a general understanding of the measures and the implications.
Okay. We have time for one more question, and it's for you, Ben. If there was more transparency as to the reasons people were on the no-fly list and opportunity for judicial review, do you think it would be an acceptable mechanism to protect national security? Or is just simply the concept of it just not fair at all?
That's an excellent question. I mean, my view is a rational, fair no-fly list would be coextensive with the people who the government is actually trying to arrest. If the government has probable cause to arrest someone, the fact that that person passes through an airport may provide a good opportunity to capture that person. To me, it doesn't really make sense to have a no-fly list that extends beyond people who the government is actually trying to arrest. Because, as I said before, you turn someone away from a plane, and into any other possible terrorist target, a train station, a bank, an embassy. Having said that, it would be a vast improvement to have a regime that provided notice and an opportunity to be heard. What we would see in the overwhelming number of these cases is that the government really has no evidence, that it's using the no-fly list in order to try to leverage informants, in order to try to get incriminating information about the people on the list or their friends and associates. Time and again, people have told me that the FBI will approach them and say, we can help you get off this list. We just need you to tell us about the Yemen community in Northern California. So that in those instances, I think if the government had to go before a judge or a magistrate and explain why the person was on the list, in the overwhelming number of cases, there would be no justification for it. So though I do question the fundamental legitimacy of a no-fly list that is broader than a list of people who the government can arrest, I still think that as an interim step, providing due process would be a massive practical improvement.
Okay, we're getting towards the end of our broadcast time today, but we have not resolved the issue in any way of travel. I'm wondering, just, you know, at the risk of opening up an entire other kind of discussion, whether we might be going towards a system, whether we like it or not, where people are going to have to be identified and classified, and all their data would be available and accessible with a microchip card. I mean, it would be sold as a convenience to people, but there must be a downside as well. Either one of you guys want to take that one on?
Go ahead.
A national identity or international identity card?
I will say this, that in the United States, the resistance to a national identity card has come not only from what you would call the left, but from the libertarian right. There is a tradition in the United States of being able to go where you want and not have to show your papers. It's not a country where you have to register with the police or with the authorities when you move from one place to another. There is real resistance to the idea of a national ID card that it cuts across different parts of the political spectrum. Having said that, I do think that the logic of the national security state points in that direction. And you're starting to see things like programs that allow you to go to a faster line in the airport if you subject yourself to a different kind of background check. I think the state will create more and more incentives for people to open up their private lives in exchange for benefits. And I do worry about the overall direction of this debate.
And what would this add to security in this case? If you were a real terrorist network, you would send a few operatives to the fast-track process, have the security checked, and some of them might clear. Then the people who are cleared, you would then use for a real operation. And it's not really a safeguard against terrorism per se. If you're dealing with smart terrorists.
Right.
It seems like we're always locking the barn door after the fact. We've had this incredible increase in security for air travel, and we can expect that the next attempt is probably not going to be an aircraft. At any rate, all of us who have the chance to travel and visit are appreciative of the fact that we're not on a no-fly list. Mazen Beg, who was our guest earlier today, unfortunately has a difficulty visiting Canada. We hope he'll resolve. We thank him for being with us earlier. Roch Tassé here in the studio in Ottawa, thank you very much for being with us. And Ben Weisner in New York, thank you.
My pleasure.
And that's us for today here on Prism TV. Thanks for watching.